The Community Safety and Policing Act has now taken effect in Ontario, and it comes with an overhaul to the rules that govern police in our province. Now, one of the new rules allows police chiefs to suspend an officer without pay in certain circumstances. Now, under the previous rules, an officer could only be suspended without pay if they were both convicted of an offense and sentenced to prison time. The act also includes a shift in the police disciplinary process, with a new arm's-length independent body being created to conduct adjudication hearings, and the new role of an inspector general who will be tasked with monitoring how police are complying with the new laws and alleged misconduct. The Ontario Association of Chiefs of Police is just one group that had been calling for reforms to the Police Act for several years now. Jeff McGuire is the executive director of that association and the former chief of Niagara Regional Police, and he joins us now. Thanks for being with us today.
Well, thanks very much. Thanks for having me.
Now, Jeff, can you talk to us about the importance of a police chief being able to suspend an officer without pay?
Yeah, absolutely. I mean, this is, as you indicated, the chiefs of police have been advocating for changes to the rules for as far back as 2010 was the first white paper that we produced and advocated with the government for change, and it required the change of the opening of the act, which has now taken place. This is based on public trust, in our opinion. There are a number of cases. First of all, I'll say up front, 99.9% of our police officers across the province, this will never touch them because they hold up their oath every day doing their job. Mm-hmm. There are those egregious cases that we felt that needed to have that opportunity, one for public trust and public protection. And we advocated for change. And as you know, there has been some change. Didn't go as far as the chiefs would like, but there has been some small step forward.
How much further would chiefs have liked this to go?
Well, I mean, when you look at what the change is as of yesterday, you know, the chief can suspend without pay for a number of offenses, but not until the point where the definition of serious offense comes into play. And that's what's been a lot of the back and forth discussion over the number of years, is what is specifically is the definition of serious offense. And it's settled in the Act with an offense that's going to be punishable by a certain term of imprisonment if convicted. But also the key point is that it has to be prosecuted as an indictable offense. So that puts the onus on the Ministry of the Attorney General. The Crown Attorney has to determine on many cases in the criminal code, which are called hybrid offenses, whether they're going to prosecute the case as an indictable offense or as a summary conviction offense. If they go by summary conviction, the lesser, then there is no authority for the chief to do that. The challenge with that, in our opinion, is, first of all, the Crown may not make that decision for quite some time after the charge is laid. So that creates a challenge there. So we would like to see a little bit more movement on that for sure. The more serious, some of the other things you touched on, serious offense, convicted and sentenced to prison, that still continues, but sometimes that can take many, many years to get to, which has been the real problem, I think, in public trust in the past.
This act also includes the creation of an arm's-length agency and an inspector general to conduct hearings and look into misconduct. How does this change the police disciplinary process?
Yeah, so a lot of the process is still kind of the same. However, the big major change, which you touched on, is who gets to adjudicate, who gets to be the judge over these disciplinary hearings, if you will. Up until April 1st, the chief was responsible for running those discipline process at some arm's length, we would argue. But generally, the person that's positioned themselves is put in the position of judging or adjudicating, has normally a senior police officer who has what we believe, all the adequate training and the ability to do so. The associations argued that, and I won't speak specifically for them, but their concern was that the person is actually acting on behalf of the chief. So how does that make it an independent discipline process, independent from the chief? This new process will do that. We still strongly believe that you know, past police officers, past senior officers that are trained in this process, know the culture of policing and know the Act, should have been included to continue being appointed as adjudicators by the office that's taking care of that. But that was not the case. There's an 18-month grandfather clause for further discussion, but we suspect that that may not be the case in the end, where adjudicators will be selected by a member of government, a specific area, that will adjudicate. So it could well be retired judges, it could be lawyers, it could be just about anybody else that meets the qualifications other than someone who has been previously employed as a police officer. So we'll have to see how that plays out in time.
You've said a few times there, Jeff, that this doesn't go as far as chiefs want it to go. What is preventing it from going much further? What's the challenge there, the hurdle?
Well, frankly, the prevention is the law the way it's written. The government, we were advocates at the table for many, many years, and certainly in the development of the Community Safety Policing Act, we've provided our advocacy and our position. There are other parties involved, which are the associations that represent the membership. I believe the government also took advocacy from different interest groups, and they settled on designing the law the way it's printed now. So they accessed everybody, they listened, and they had to lay down the law at the end of the day. We're responsible to follow what's been printed and what's been accepted as the law, and that's where we are now. So clearly, the government knows that we would have liked to. We think, and it's not. No chief takes any great pleasure in doing this, but let me assure you that chiefs want the opportunity to help maintain public trust. And frankly, we think that this is a bit of an impediment when there are cases where, I had it when I was a chief. When I get out of my car in my driveway and I get home and have a neighbor look at me and seen something in the news and says, "How can this be?" And it's and again, a very small scintilla of a percentage of the great police officers in this province will ever be touched by this legislation. But there are some that we would like a little bit more authority on.
Listen, Jeff, we're running out of time, but I just want to ask you quickly, unfortunately, why is this public trust so important?
Well, police services can't function. We can't uphold our role. We're given great powers and authorities to maintain safety in the communities. And if the public does not trust what's going on in police services, then we just can't do our job. In community safety, we don't have those partnerships. And it can be hard for the public to look clearly and say, well, that officer is charged with this offense and we're still paying his salary for X number of years. That impacts trust. I don't think there's any doubt about it.
Jeff McGuire with the Ontario Association of Chiefs of Police. Thanks so much for your time today.
Thank you all. Thanks very much for the opportunity, and stay safe.